Hi everyone. So again, my name is Kyle. I will talk about the second part of the human rights lecture today. I will talk about the legal and philosophical foundations of human rights and some of the debates that are ongoing in this field. I'll also talk a little bit about international human rights law, and this will be super useful for aspiring law students and stuff like that. It's a little bit advanced, which is why it's super important to have like a PowerPoint because there's a seven-step process that we're going to be discussing later. And I'm a little bit excited about that. All even if it gives me a throwback to law school. But anyway, we'll start with the legal and philosophical foundations first. This is a topic that some people find fascinating because it deals with the origins and reasons behind the human rights that we enjoy today. I will discuss this in two main parts. I'll talk about natural law, and I will also talk about legal positivism. Then we'll move on to the types of human rights and their sources, and lastly, we'll talk about some debates about universalism versus cultural relativism in human rights. But before that, I want to have a few disclaimers. The first one, obviously, is that I don't have a monopoly on knowledge. I'm not really a super expert on these kinds of things. I have not done international law work, although I know quite a little bit about it. But secondly, I feel like more importantly, this is not legal advice. Even if I were to give this lecture like 2 days from now when I'm officially a lawyer, this would still not be legal advice. It's just me sharing stuff that I learned from law school and some of my own research along the way. So, with that being said, let's move on to the first part, which is the philosophical foundations of human rights. The first part of this is my favorite because I always love the idea of where do we get the rights? Because ever since I was a child, I've always been fascinated about why is it that I am allowed to do some things and I'm not allowed to do other things? Like, I want to know the limits of what I can get away with, and that sounds quite sinister. But yeah, that's the reason why I'm super fond of this topic, and that's also one of the reasons why I took up so many philosophy classes in my undergrad years because of things like this. So we start with natural law theory, and the natural law theory is all about the design of the nature and the universe. It comes from a premise that the natural order is superior than human-made order. And you can see the influence of religion here because that's the same thing that we say about divine law or the law of God. So indeed, while the true roots of the natural law theory of rights began in ancient Rome with people like Grotius, its formulation as today follows either a theological path or a rationalist path. So I want to talk about this next. Human rights basically are derived from universal moral principles, and these would be independent of human made laws. And it depends on how we consider or how we conceptualize the state of nature. And so here we're going to be talking about John Locke and Immanuel Kant. And they also represent, each one of them represents the two paths that I was talking about, where John Locke represents the theologian path of creating human rights under the natural law theory, and Immanuel Kant represents the rationalist path, and we'll take that up later. So first, let's talk about John Locke. In his two treatises of government, he puts forth the idea that individuals possess inherent rights that exist independently of any government or social order. And Locke's conclusion was basically that these inherent rights, based on his observation of human beings in a state of nature, and in the state of nature, this is a hypothetical condition. That is, before the existence of organized societies, individuals were free and equal. And so Locke argued that even in this state, people had natural rights to life, liberty, and property, which were derived from the laws of nature and obligations imposed by God. Here's where we see a strong influence from religion. Locke was a devout Christian. Some scholars believe that this fed into his moral philosophy because it posits that man exists in a world created by God for God's purposes, but that governments are created by men or humans in order to further their own purposes. So human rights are there not because of humanity's like purposes, but because it was the way that God made us. And so religion played a significant role in Locke's formulation of inherent rights. He believed that all individuals were God's creation and as such possess certain inalienable rights granted by the creator. And this might be the way that you've come to learn about human rights in grade school. Certainly, this was the way that I learned about human rights in grade school. That being said, I always had questions of, oh, so God gave us the right to have fun. It's a God given right. It's a God given right to, let's say, have work. Is it a God given right for me to work at Facebook and stuff like that? So it was a bit vague for me at that time. But I'm pretty sure that this is how most of us in the Philippines learned about human rights as something that was granted to us by God, and we can not alienate for any reason. So Locke argued that these rights could not be taken away or violated by any authority, including governments, because if governments do that, it would be an attack on God and God's creations. And so, by grounding his theory of natural rights in religious doctrine, Locke provided a powerful justification for the protection of individual rights against arbitrary government actions. And I think more importantly, this was in stark contrast to the idea of the time, which was that humanity was meant to serve under a single monarch or a single king. While this was written in the late 1600s, this philosophy would eventually come to be used by Thomas Jefferson's Declaration of Independence in 1776 and also the French Revolution. But also, and this leads me to the next thinker that I want to talk about, which is Immanuel Kant. So he's another natural law theorist, and he proposed something called the categorical imperative. And the categorical imperative, or the CI, emphasizes the importance of rationality and autonomy in ethical decision making. So if you want to learn more about Kant, specifically his oops. So if you want to learn more about Kant, specifically his views on natural law and morality and human rights, check out the groundwork of metaphysics. Check out the groundwork of the metaphysics of morals. And I think you can find a copy on Google Scholar. So Kant believed that natural order was not based on a divine or natural order, but rather on the rationality of human beings. He basically argued that you can have moral principles that you could derive and reason out for yourself, wherever you are, and that these principles should be universally applicable to rational beings. So this approach allowed Kant to develop a moral framework that was objective and universally binding without relying on religious or cultural assumptions. So basically, he was saying that because we exist in this world and we're rational beings, we can think for ourselves and we know when we're in pain and we can make sense of the pain that we feel, and whatever other emotions that we feel, we can make sense of it and put meaning onto it. This must mean that we were meant to enjoy a dignified standard of life where those negative feelings are minimized. And this also means that because we desire like a greater sense of purpose, or we desire like better standards of living for ourselves, that must mean that inherently we do have a right to these things. And so the categorical imperative is basically, if you just want to sum it up, the categorical imperative is a moral rule that you can universalize. And so we might talk about this again in a future philosophy lecture, but basically that's what it is. Something is moral if you can universalize that action and the world won't go to crap, right? Basically, it's saying that if you are posed an ethical decision, if you make a decision, you also have to think about, what if everyone else in the universe does this? Will it make the world a better or a worse place? So if it is something that you can universalize, then it's something that is good. And so if you're bringing it back to human rights, if you treat someone with respect, respecting their rights, respecting their dignity and stuff like that, if you universalize, that would make the world a better place. On the other hand, if you're trying to interfere with their exercise of their rights or deprive them of their rights, if you universe, that's not a good thing, right? So it's not on all fours with the idea of the categorical imperative. And this also means that people are not just means to an end, but an end in themselves. This is one of the formulations of the categorical imperative. The idea that no one in the human race is just here in order to serve someone else, but they are independent and autonomous beings as well that are inherently dignified, and we should protect that dignity. So if you're going to take a look at the natural law theory, if you look at motions like this, how supports establishment of a global legal framework for, let's say, environmental rights, the natural law theory argument for the motion would be that from a natural law perspective, environmental rights can be considered an extension of human rights. Since the natural environment is the foundation for human well being and flourishing, and therefore establishing a global legal framework for environmental rights aligns with the natural law theory's emphasis on the interconnectedness of human rights and the moral duty to protect the common good. So, in principle, by recognizing and enforcing environmental rights on a global level, governments can ensure the protection of natural resources that are essential for human survival and well being, which is consistent with the core principles of natural law. But on the other hand, you can have a natural law theory argument against this motion by saying that opponents of a global legal framework for environmental rights could argue that the natural law theory's focus on human rights and autonomy could be undermined in this kind of framework. For example, you might be able to argue that a global framework would infringe on the sovereignty of individual nations, right? Why is it that Brazil, it's not their fault that they were born with the Amazon forest, but it would be the fault of the entire world if they were deprived from the ability to use the resources within their disposal to make the lives of their citizens better, right? Instead, what you might argue on opposition here is you want to have a more localized approach where each nation or region would probably develop their own legal framework for environmental rights in line with their unique cultural, social, and environmental contexts. And this would preserve the balance between protecting the environment and respecting human rights and autonomy in accordance with the natural law theory. So that's it for the natural law theory. The next thing I want to talk about is legal positivism. This is the school of thought that posits that human rights are established by human-made laws rather than any inherent or universal moral principles. And there are three key thinkers within this theory. One is Bentham, one is Bentham, and we'll take him up right now. The next one is John Austin, and the third one is H.L.A. Hart. So Jeremy Bentham said that basically human rights are nonsense on stilts. He's famous for saying something like this, right? He rejected the idea of inherent and inalienable rights, and instead he believed that rights were socially constructed, originating from laws and social agreements, and he argued that the existence and legitimacy of rights were contingent upon the actions and decisions of government. And these actions of government should be based on the principle of utility. And utility, as defined by Bentham, is a measure of the overall happiness or pleasure that is derived from a particular action or decision. So, in his ethical framework, which we know as utilitarianism, an action is considered morally right if it produces the greatest amount of happiness for the greatest amount of people. So, this approach to ethics and law is grounded on the consequences of actions that prioritizes the promotion of collective well-being over individual rights. And Bentham's utilitarian approach to human rights is also grounded on the notion that rights, wherever they are, whatever they may be, should serve the common good and be evaluated according to their capacity to promote overall happiness. So, for Bentham, human rights are not inherent, they're not sacred, they're just instruments. Instruments achieve social welfare and should be granted or limited based on their usefulness in maximizing utility. And therefore, this implies that rights can be adjusted or even revoked if doing so would lead to a greater overall happiness for society. So obviously you can see some criticisms here. Like if even, for example, the right to life, if you can revoke that for the greater overall happiness for society, what does it mean for Logan Paul? What does it mean for the politicians you don't like? Is it fine for us to just take away their right to life whenever we feel like everyone will be happy? Like drag them to hell because you're gonna kill them, right? So you can see some criticisms here. Like you justify the infringement of individual rights in pursuit of the collective good, and that might sometimes include minority rights. So if their rights are seen as detrimental to the happiness of the majority, like for example, if we're talking about the rights of ethnic or racial minorities, right, or gender minorities, the utilitarian view would basically say, no, you are suffering But if we're going to give you more, it will introduce even more suffering, more chaos. And so we should just leave things the way that they are. So this criticism highlights the potential conflicts between the utilitarian approach and the protection of universal human rights. The next guy. I just want to note that most of these people are white men and many of them are very racist. But anyway, John Austin had this idea of the command theory. He was the quintessential legal positivist, and he developed the idea of positive law and command theory, which offers a distinct perspective on the nature and origin of laws. So, in contrast to natural law theorists, Austin did not believe that laws were derived from a higher moral or divine order. Instead, what he said was laws are just commands issued by a sovereign authority that holds power over a given territory and population. So this view of law centers on the idea that legal systems are based on the exercise of political authority and the imposition of rules by a sovereign. So in his work, The Province of Jurisprudence Determined, he distinguished between three key elements: a command, a sovereign authority, and subjects. So a command, according to Austin, is an expression of a desire by the sovereign authority. It might be the government, it might be the president, it might be the king, whoever embodies that sovereign authority when they aim to regulate the behavior of the subjects. And sovereign authority is the entity that has the power to issue commands. Subjects, on the other hand, are just individuals who are obligated to obey those commands. So there is a clear hierarchy. There's a coercive nature in legal systems that emphasizes the role of power and control in the creation and enforcement of laws. So when I was in law school, one of the papers that I wrote, one of my favorite papers, was saying that laws in general are immoral insofar as they are coercive commands that force people to be things who are other than themselves, right? And so it flies completely in the face of Immanuel Kant's idea of that we're all ends in ourselves. So if we can be coerced into doing something that undermines our authority, and if we also take into consideration the fact that laws are not just laws, they have like ideology back and baked into every single one of these laws, you're basically imposing upon everyone different ideologies that they might not agree with. And for that reason, I argued that all laws are immoral. And it's probably not something that I should be saying like the night before I take my oath as a lawyer. But yeah, they can sue me. I don't know. So, yeah, under this framework, rights can be granted are modified or revoked by the sovereign authority, and this reflects the fluidity and contingency of legal rights in a positive law system. So again, it's not about like moral truth. It's not about the universe. It's not about natural law. It's about the whims of a person, the whims of a sovereign authority. So the protection of human rights could vary depending on the whims of the ruling power and not necessarily grounded in universal moral principles. So obviously, like if you're going to critique this, you can say that you're not accounting for the moral dimension of human rights because you're reducing the concept of law to the expression of political power. There's another philosopher, I forgot to put them here because in the interest of time, I'm just like, but yeah, one of these philosophers went against John Austin by saying that one of the things that we look at is not just morals, unlike Kant and John Locke. It's not just commands, but it's also an embodiment of tradition. So if human rights are part of our tradition, and indeed it is for many places in the world, then John Austin is wrong. And it points to the potential dangers of a legal system that doesn't recognize the importance of universal human rights and values, as it might leave individuals vulnerable to arbitrary decisions of a sovereign authority. But that leads me to the final thinker I want to talk about, which is H.L.A. Hart. So what he said was it was a version of legal positivism that diverged from Bentham and Austin. Hart's positivism says that there's a separation between law and morality. So laws can exist independent of moral content, and this idea is the separation thesis. So in the concept of law, which is his seminal work, he presents a more nuanced account of legal positivism. by introducing the idea of primary and secondary rules, from which the foundation of a legal system are formed. Primary rules are the substantive rules governing behavior. Secondary rules are procedural rules that address the creation, modification, and interpretation of primary rules. So that's a lot, right? But basically, what we're saying here is that when we're talking about substantive rules, what we mean by this is these are the principles around which all of our behavior should be based. And the secondary rules are just about the process by which we change those primary rules. So here, in the Philippine context, what you would say is, okay, there's a primary rule that says don't kill someone. But if you ever want to legalize killing another person, what you want to do is go through the secondary rules, which are the rules that govern like legislation and stuff like that. Hart's framework is a more accurate and realistic depiction of legal systems because he recognized the complexities of lawmaking and enforcement processes. So it has implications for our understanding of human rights because under this framework, human rights can be seen as established by primary rules within a given legal system. And these rights are not necessarily grounded in morals or ethical principles and may instead reflect the policy preference or political goals of a society. So not just a sovereign authority, but the society in general. And so in this way, human rights can vary across legal systems and are not inherently connected to universal moral values. So if we're going to connect this idea of positivism to, let's say, emotion, like countries should prioritize economic development over the protection of individual human rights, one legal positivist argument for the motion would be to say that human rights are derived from the laws that are enacted by government and not from any intrinsic moral principles. So if you want to support prioritizing economic development over individual human rights, you can argue that the government has the authority to decide which rights to prioritize through legislation. And by focusing on economic development, by the way, there is a human right to development under the International Covenant on Economic, Social, and Cultural Rights. By focusing on the right to development, a country can create the necessary legal framework to stimulate growth and prosperity, which may in turn lead to improved living standards and the eventual enhancement of human rights in general. So, this approach aligns with legal positivism when you emphasize the role of governments in determining and enforcing human rights. On the other hand, if you want to argue against this motion using the lens of legal positivism, you can point out that existing human rights must be respected and enforced because they are already rules. And you can argue that if you neglect human rights in favor of economic development, that undermines the rule of law and may lead to social unrest, instability, and long-term negative consequences. So instead, you can advocate for more balanced approach where both economic development and human rights protection are considered essential components of the legal framework. So this leads me to a very important question that many of us look at, which is, are human rights effective? So what I would say is, this is my personal opinion, human rights are effective to an extent because they're only effective if we demand that they are effective. And if you forget to demand that they are effective, they will no longer be effective. For example, the Philippines is a party to so many international human rights treaties. For example, the ICPR, the ICESCR, the CRC, CEDAW, the ICERD, or the International Covenant on the Elimination of Discrimination Against Racial Discrimination, all forms of racial discrimination. And yet, we see that sometimes we don't actually see those things being implemented. And my favorite example of this, it's my favorite because it's so sad. And it really emphasizes and highlights the importance of demanding that human rights be effective, which is the case of Benjamin Hernandez. So in the early 2000s, during the time of Gloria Macapagal Arroyo, we saw a lot of killings of student journalists. And Benjamin Hernandez was one of these student journalists from, if I'm not mistaken, Ateneo de Davao. And they tried everything. The family tried everything to bring the killers to justice. Kasi um, yung pumatay ay state forces, the military. In fact, one of the killers was actually promoted in the military. So they brought it up to the UN. And the UN said that, oh, human rights violations were definitely made. You were not following your obligations under international human rights law treaties. And so there was a decision made against the Philippines, but nothing happened after that. The Philippine government was supposed to report back within a few months. But almost 20 years later, nothing significant has happened. And even during the time of Pinoy, Noy Noy, the CHR asked the executive branch, hey, can we actually do the things that the UN asked us to do? And nothing happened still. So without people like us to actually demand that human rights instruments be effective, they're not going to be effective. That's what I would say. Because if the people in power benefit from ignoring human rights, they will ignore human rights. So it falls on members of the society, like people like us, to actually remind the government that we do have obligations for human rights. And if we don't do that, unfortunately, we run the risk of just not having anything like that happen. So, yun. Yeah. So, next, let's talk about the types of human rights. That was a big shift in tone. Let's talk about the types of human rights. There are two broad categories, and I sort of foreshadowed this in a previous lecture when I talked about the ICPR and the ICSCR. I'll talk about both of them. The first is civil and political rights, and the second one is economic, social, and cultural rights. So, with respect to civil and political rights, I want to highlight a few things. The first one is, as a definition, they include the right to life, liberty, and security of person, as well as the right to freedom of speech, assembly, and religion. So they protect individuals from undue interference by the government. Second, how do they differ from economic, social, and cultural rights? In their nature, focus, and the obligations they impose on states. First of all, civil and political rights, let's call them CPRs, they're also known as first generation rights. They're primarily concerned with protecting individuals from undue interference by the government, and therefore we call them negative rights. It's not freedom of, it's freedom from. So when we're saying we have freedom of speech, what it actually means is we have a freedom from government interference in our speech. And these rights aim to ensure that individuals have the freedom and autonomy to express their opinions, practice their religion, participate in the political process. On the other hand, economic, social, and cultural rights are sometimes referred to as second generation rights or positive rights because they focus on the state's positive obligations to provide certain goods and services such as education, healthcare, adequate living conditions to the citizens. So while CPRs often require states to refrain from certain actions, ESCRs call for active measures by states to fulfill their citizens' needs. Next, I want to talk about how CPRs get ESCRs. So if you can only prioritize one type of right over the other, how would you argue that? I would argue that the CPRs can contribute to the development necessary to fulfill economic, social, and cultural rights by safeguarding freedoms of expression, assembly, and political participation. Civil and political rights enable individuals and civil society organizations to voice their concerns and hold governments accountable. So that's the first part, right? Enables you to voice out your concerns. And this in turn fosters transparency, good governance, and a more inclusive decision-making process, which can lead to a more effective and targeted policy aimed at addressing social and economic challenges. And furthermore, the protection of civil and political rights can encourage investment, innovation, and economic growth by creating a stable and predictable environment in which individuals and businesses can operate. So in this way, realizing CPRs can lay the groundwork for achieving the development necessary to ensure the fulfillment of ESCRs. So next, let's talk about economic, social, and cultural rights, ESCRs. So first, what are they? They are the right to education, they encompass the right to education, health, and work, as well as the right to an adequate standard of living. These rights focus on ensuring that individuals have access to basic resources and opportunities needed to lead a dignified life. What I will what I will note, and this is something that I need you to remember about economic, social, and cultural rights, is that even though we have a binding treaty, the International Covenant on Economic, Social, and Cultural Rights, even though we have that binding treaty, states that are parties to this do not have to guarantee that everyone should have a fully fledged right to education, health, and work, etc. immediately. Because within that covenant, there is the concept of progressive realization. So, according to this principle of progressive realization, states have a continuous obligation to take steps towards the full realization of economic, social, and cultural rights. However, this understanding recognizes that the fulfillment of these rights might not be immediately achievable, especially if you're a developing country, right? So just because not everyone has work right now doesn't mean that the government has failed in its obligations, because this obligation is for the progressive realization of these rights. Unfortunately, some states took that and started abusing it by using it as an excuse not to act or to delay the implementation of their obligations under the ICESCR. So they may, for example, argue that the full realization of the rights or the full realization of these rights is an idealistic goal, or that their limited resources prevent them from prioritizing the fulfillment of economic, social, and cultural rights. And also, this interpretation of progressive realization can lead to a lack of urgency and commitment to advancing these rights. And in turn, that perpetuates inequality and social exclusion for the most vulnerable populations. So, the next thing I want to emphasize is what I feel to be a better understanding of this principle. I think a better understanding of progressive realization emphasizes the role of states as primary duty bearers under the ICSCR that's responsible for using all available resources to advance the enjoyment of economic, social, and cultural rights. That means states must prioritize their resources and policies in a way that ensures continuous progress of their obligations, while also taking into account their obligations towards other human rights. So, states are required to ensure non discrimination and equality in the realization of these rights. So, you need to pay special attention to the needs of vulnerable and marginalized groups. And the reason why I feel like this is a better understanding is because in the first article of the ICSCR, it says each state party undertakes to take steps to the maximum of its available resources and with a view to achieving progressively the full realization of the rights recognized by all appropriate means. So there are two phrases I want to emphasize here. The first one is maximum of available resources, and the second is all appropriate means. And this shows that you can't dilly-dally here. You still need to act. With this in mind, the obligations under the ICSCR is not to make sure that everyone has it immediately, but rather to do everything the state can do to get them. So this means that under this covenant, the state violates it when it has the capability to realize the right, but they choose not to, which is a lower burden for people like us when you say you are violating the right. Because the only thing that you need to show is you do have some extra resources that you could have used to protect the rights of the vulnerable, but you chose not to do it. So, I mentioned next, there's one difference between CPRs and ESCRs, which is that CPRs are negative rights, meaning all the government needs to do is not intrude, whereas ESCRs are positive rights, meaning that the government actually needs to spend some money. So in this way, people argued that, especially Westerners, they argued that CPRs are more important than ESCRs. Since if you need the government to do something, then it's not really inherent to the human condition. My personal opinion is that this is a false dichotomy. The West is wrong because it's based on the false premise that you don't need to spend to protect CPRs when they actually do. you need to spend on the courts, for example, to provide remedies when civil and political rights are violated. You need to spend money training the police to respect CPRs. You need to spend money creating spaces where people can protest together. And in fact, here in the Philippines, while you're not allowed to protest wherever you want without a permit, there are free speech zones in every city dapat where you can go, and even without a permit you can do a protest, right? So even without a permit, in some places you can use your civil and political rights, but the state needed to spend money to create that freedom park. They call them freedom parks. So I think that the positive negative rights dichotomy is not true, right? Like it's a false dichotomy. So really, if that was the difference between economic, social, and cultural rights and civil and political rights, and I just rebutted it, what's the difference? I'll talk about that later because I don't think that there is a difference. The only reason why we pretend that there's a difference is because of some international relations drama. And that's what I'll talk about in the next slide. But as a final point for this slide, I think you can argue that focusing on ESCRs can contribute to the realization of CPRs. Because if you ensure that individuals have access to basic resources and opportunities, such as education, healthcare, and work, you create an environment where people can lead dignified lives and participate effectively in the political process. And also, if you fulfill economic, social, and cultural rights, it can promote social cohesion, stability, and trust in institutions, which also creates a more conducive environment for the protection of CPRs. But also, on a third level, if you prioritize education, at some point, people will be able to rationalize that, hey, people should have rights. People should have like dignified lives. People should be able to ask the government for redress. People should be able to have freedom of religion and stuff like that. And that's the reason why, even in the Philippines, there are some people who have been fortunate enough to be able to get an education, to live like a privileged life, and they started a revolution that empowered everyone eventually to have civil and political rights. So that's those are a few things that you can argue. So assuming that they are mutually exclusive, you can argue that. That being said, I don't think that they're mutually exclusive. But if you have to defend one or the other, I'm just giving you the options. So I mentioned earlier that if the difference between CPRs and ESCRs was that one is positive and one is negative, and I just rebutted that, what is the difference? And I said that there is no difference. It's just that we pretend there is because of international relations drama. That's the next slide. I want to talk about the evolution of the ICPR and the ICESCR. Because once upon a time, we mentioned this in the previous lecture, we had the Universal Declaration of Human Rights. So some of you might know that the Universal Declaration of Human Rights is not binding. It's not a treaty. It's basically just saying that, oh, okay, we believe in these principles, but if you violate those principles, nothing will really happen. It's not a treaty. It's not even an agreement. It's just a declaration. The international community, upon signing it, said, we need to expand on this to make it binding. So the initial plan was to have just one instrument that covers all of the rights that are involved or implied in the Universal Declaration of Human Rights. The problem was Western thinkers were saying that no, let's not talk about the right to work, let's not talk about the right to property because we're capitalist countries and we don't want poor people to have a dignified standard of living if we can profit more from them being poor. This is me not being generous. The more generous way to view it is we are the West, we believe in liberalism, we believe in small government rather than big government. So because of this idea, we oppose the concept of economic, social, and cultural rights where the government has to intervene. On the other hand, Eastern countries, especially socialist countries, were saying that no, in order for anything to work, we need to have the sense of a dignified standard of living and not just freedom from government interference, right? So these kinds of freedoms should be embodied in another instrument as well. So their disagreement between the Western countries and the socialist Eastern countries created a split And now we know them as the ICPR and the ICESCR. And in fact, the Eastern countries were so adamant about this that even though they were arguing, the ICESCR was ratified and made first. That's how important this is for the Eastern socialist countries. They deprioritize the idea of individual, like, freedom from interference, although they do believe in that to some extent. They believe in the right to work, they believe in the right to healthcare, the right to education, much more. And that's the reason why we pretend that there's a difference between CPRs and ESCRs, when really they're both the same, right? It's just that one set of rights is more palatable to the West and one set of rights is more palatable to the East, even though in both sides, there will still need to be some degree of state action. Okay, so next, let's talk about international law. Let's talk about the sources of human rights. I'll talk about the different sources of human rights, and then I'll talk about, and also the different sources of international law, and then I'll talk about how we use international law in the domestic context. And that last one is incredibly important if you want to be a law student. Actually, this entire section is important if you want to be a law student. But the most important, in my view, is the last one. How do you apply international law to the domestic context? Because so many people are like, oh, it's not real law. You don't really, yeah, it's a worthless scrap of paper. But really, it's more than that, especially if it undergoes the process of domestication, which I'll talk about in a bit. So first, let's talk about treaties. So the treaty is a primary source of international law obligations. A treaty is basically just a formal agreement between states that establishes binding legal obligations under international law. They provide a framework for cooperation and coordination among states and serve as an essential instrument for promoting the rule of law and the protection of human rights at the global level. And treaties can cover a wide range of subject matters, including trade, security, environmental protection, and for our purposes, especially human rights. But what we need to note is that it doesn't need to be called a treaty. So something that we call a convention, if it's a formal written agreement between states creating legal obligations, then we'd still consider it a treaty. It also doesn't need to be just one document. It can be in like many different documents that you compile together and call it a treaty. It can even be on like truly a piece of toilet paper or something, because it would still be a formal written agreement between states. And if it establishes binding legal obligations, that is a treaty. The problem with a treaty is sometimes, although it creates binding obligations, it does not give any remedies or enforcement mechanisms. And that's the reason why, let's say, like the Paris Accord. The Paris Accord is a treaty that it aims to protect the environment. Unfortunately, under the Paris Agreement, there aren't a lot of enforcement mechanisms. So when you are a diplomat, right, one of the things that you want to take a look at is how do you make sure that this is enforced? Yeah. So next, the VCLT is the Vienna Convention on the Law of Treaties. People call it the VCLT or the VCLOT. The VCLT sets out fundamental principles that apply to treaties. One is the Pacta Sunt Servanda rule. And this rule obligates states to perform their treaty obligations in good faith. And there's also the principle of consent, which you can find in Article 11 of the VCLT. And this requires states to voluntarily agree to be bound by a treaty. So these two principles are embodied in the VCLOT. And they show that once a state agrees to be bound by a treaty, it limits its own sovereignty. So, for example, if a senator ratifies a treaty, let's say to be part of the International Criminal Court, and that senator becomes the president, that person can't double back and say, that was a bad idea because it limits our sovereignty. That's just part of the package. When you ratify a treaty, you're already limiting your sovereignty. That's the principle of auto-limitation of sovereignty. So you can't just double back after ratifying a treaty and say, yeah, that was a bad idea, because it was your idea to do it. Anyway, that's not really relevant to anything that's going on in status quo. I just wanted to give a hypothetical situation. But in the connection between treaties and human rights, treaties are the primary source of international human rights law because they create specific rights and obligations for state parties and provide mechanisms for monitoring and enforcement. So the ICPR and the ICSCR, they do have mechanisms for monitoring and enforcement because they're attached to the UN. So if you go to the UN and go on their Committee for Economic, Social, and Cultural Rights and say these rights have been violated, they can give a decision, although they don't call it a decision. So here in the Philippines, if a court says, "Oh, we've released a decision, you violated the law," in the UN, they say you violated a law, but we don't call this a decision. We call this an adoption of views because calling it a decision is too harsh now. So you can see like the UN kind of skirting around their burden a little bit and no, it's just our opinion. Like you don't need to pabebe sila. So key human rights treaties include the ICPR, the ICSER, the Convention on the Elimination of All Forms of Discrimination Against Women, or the Convention of the Rights of the Child, etc. And these treaties establish universal standards for the protection and promotion of human rights and provide mechanisms such as reporting procedures, individual complaints, we call those communications, and state to state dispute resolution to ensure compliance with treaty provisions. However, their effectiveness depends on the willingness of states to ratify and implement the treaty provisions. Non states are not bound by the treaty obligations. So, in PSDC, so I'm not sure if all of you are updated on PSDC. In PSDC, one of the motions was about the idea that the UN should sanction states that are near Myanmar for turning away refugees. Are you all familiar with that? Nakita nyo ba yung motion, yung PSDC motion na yun? I'm not sure if you're all like participating in PSDC eh. But the problem is this region, yung surrounding region ng Myanmar, that's Southeast Asia. And Southeast Asia did not ratify and did not accede to the Refugee Convention. So technically, they weren't even violating any aspect of international law or especially treaty law. And so in it's fine to talk about it in theory, but in practice, what would the UN do? I think you can actually make that a part of the argument and say that, okay, cool, you're right in principle, but think about the bad will, or the backlash that you're going to get from these countries who are being imposed an obligation that they didn't accede to because they're not part of the refugee conventions. And this will make them lose faith, not just in the UN, but the entire international legal system. And that would be even more disastrous for the future. What would be better would be to assist them in accepting the refugees or assist them in turning those states into holding areas so that they can send them to other places. The only two countries, as far as I know, that in the Southeast Asian region that accepted, ratified, and acceded to the refugee conventions are the Philippines and Cambodia. Cambodia, that was because after the fall of Pol Pot, there was a lot of effort in rebuilding their institutions, their democratic institutions. And as checks and balances, they also had Cambodia accede to many human rights treaties. The Philippines has had a very long relationship with refugees, super duper long. As in, even before World War II, even before the Refugee Convention, we have already been helping out refugees as much as we can. In fact, during World War II and the events before World War II, we were already accepting Jewish refugees from Nazis, from the Nazi government. Like they were fleeing and we were taking in Jews. And there's more drama here because during the time, we were not an independent country. We were part of the American Commonwealth. And the American government has a lot of Jew haters, like anti-Semitic people. So when President Quezon said, I want to help the Jews who are fleeing their country, our American overlords were like, no, don't do that. So there was a lot of gambling involved here where Quezon was pretending that he wasn't helping, but he was actually totally helping. their effectiveness depends on the willingness of states to ratify and implement treaty provisions. Also, some treaties might not always provide comprehensive protection for all human rights or adequately address emerging human rights challenges. So that might require the development of new treaties, new customary international law, or new general principles of law to fill in these gaps, which leads us to the next source of international law, which is custom. Customary law. A custom is basically just a general and consistent practice that states have done throughout history that are accepted as law. So its purpose is to complement treaties, to establish legal norms and rules that govern the behavior of states. So where there is no treaty, customary international law fills in the gap. There is some debate about how long it needs to be practiced before it becomes customary law. It's still debatable in like legal scholarship about whether you can have an instant custom. Was there an instant custom to like you when you drop a nuclear missile into a city and then it killed a bunch of people? Nagkaroon ba ng instant custom to say that's messed up? So that's still debatable. And I am not equipped to do that debate because so many people have talked about this. So what I would just suggest is just put it on Google Scholar, say instant custom international law, and read. Do your own research, guys. It will be so fun. But it's very technical kasi. That's why I didn't put it here. But anyway, there are two elements in customary law. One is state practice. I mentioned this earlier, which the accumulation of consistent and general state practice. They need to be doing it. And secondly, they must be doing it with the belief that the practice is generally legally required. And this is opinio juris. Opinio juris just means that you're doing this practice because you believe that it is legally required. It's an obligation. So evidence of customary international law can be found in many sources, including diplomatic correspondence, official statements, national legislation, judicial decisions, and the practice of international organizations. So one of the things that you can do is go on Google Scholar and ask new customary law, an analysis of state practice, and you might find that there are some new aspects of customary law that you're not aware of. For example, some people think that going into another country to not to attack that country, but to attack a specific part of that country, like a terrorist group is hiding out in Pakistan and you are in Afghanistan, for example, or you're the United States, do you have the right to enter Pakistan to attack this terrorist group and not Pakistan as a whole? Because under treaty law, this would be considered a violation of Pakistan's sovereignty, and this would be illegal. This would be a crime of aggression. But, and this is my thesis in law school, what I said was, if you, based on customary international law, you can do that provided that you do it's necessary and it's proportional to the force that was done against you. Okay, as related to human rights and customary international law plays a significant role in the development and enforcement of international human rights law. So many fundamental human rights principles, such as the prohibition on torture, genocide, slavery, they have their origins in customary international law. So there is a treaty against torture. There is a treaty against genocide. But a lot of these provisions are just codifications of something that we already knew in customary international law. The only other thing that they did was not just to codify, but to add like additional limitations, additional frameworks that let us better understand our obligations. So dagdag lang siya sa customary international law. Customary international law can also provide a basis for the protection of human rights in situations where a relevant treaty is not enforced or does not cover specific issues. So for example, in the PSDC motion about refugees, what you can say is, okay, on Gov, you can say, sure, they're not a part of the refugee convention, but under customary law, they still have an obligation not to send a refugee back to a very bad situation, or we call that the non-refoulement principle. You can say that even if it's in the refugee convention, it was actually part of customary law. And even in the Southeast Asian region, we see a lot of this principle popping out throughout our history. And I also have a book on this that I'll have to open it up and give you like the individual aspects. But we do have a very strong practice of protecting refugees in this region. However, the snag that we find ourselves in is we usually see it as a political act because the main standard for when someone is a refugee is, are they fleeing from prosecution, unjust prosecution? So if you are going to accept refugees from another country, let's say the Philippines accepts refugees from Cambodia or accepts refugees from Myanmar, the understanding there is you are saying these people are being persecuted by the Cambodian or the Myanmar government. And therefore, it is also seen as an attack against those specific governments. And that's the reason why, generally, our region does not want to enter the Refugee Convention. As opposed to places like Africa, where the entire region came together and said, oh, let's agree how when we're going to accept refugees, that's not an attack on you. This is a non-political thing. This is a humanitarian thing. And this is one of the ways that Africa is actually better than the rest of the world when it comes to human rights law and implementation, because they have harnessed the concept of regional human rights institutions. Customary international law can provide bases where there is no treaty. Sorry, I forgot to bring it back to the refugee thing. One of those customary international law concepts is the prevention of transboundary harm. Transboundary harm. So, what you can say is by stopping people, by refusing refugees, you are making the situation in Myanmar much worse because you're adding to the instability there. And so you're actually violating some of your customary international law principles or obligations. But one of the biggest customary international law principles is what we call use cogens or peremptory norms. So certain rules of customary international law are considered to be of higher status. Yan yung use cogens, peremptory norms. These norms are non-derogable and are universally binding on all states regardless of their consent. Kasi the general rule for custom is if when the custom is being created, a state can say, no, I will not form part of this custom. I will not agree to this custom. So you'll be exempted from that custom. The problem is, if it's a use cogens norm or use cogens custom, even if you object to it at first, that doesn't matter. It will still be binding on you. For example, prohibition on genocide, torture, crimes against humanity. Even if you don't say that you agree with this custom, you're still bound by it. Because a violation of a peremptory norm can even give rise to individual criminal responsibility and may trigger the international community's responsibility to protect. Because generally, if you're going to violate international law, the person that is responsible is not the individual, but the state. But if we're talking about use cogens norms, because it's so important to us, we don't just look at the state, we look at the individual. Because no state that's worth its salt would violate these things. No state, we assume, would actively do genocide. Rather, it must be the fault of individuals who manipulated the population into agreeing to have a genocide, and that's why they need to be held liable. Okay? Next, I'll talk about general principles of law. So, there are fundamental legal concepts that are common to major legal systems in the world, and they provide a basis for resolving disputes or filling in gaps when treaty and customs don't do the trick. So these principles are derived from shared legal traditions of diverse jurisdictions and reflect a global consensus on the basic tenets of justice, fairness, and the rule of law. So one of the differences between a general principle of law and a customary law is it's in the name. A custom is a practice, whereas a general principle is a tenet. It's a principle that they hold dear. So when confronted with a legal issue that's not directly addressed by treaties or state practice, International courts and tribunals may rely on general principles of law to resolve disputes and to ensure the principled consistency and coherence of international legal norms. So, if you relate this to human rights, general principles of law are significant because it helps you interpret and develop human rights norms. So many human rights concepts such as fair trial, right? Non-discrimination, those are rooted in general principles of law that have been recognized across different legal systems. Okay? It's 9:21. Should I take a break? Because my throat is killing me right now. Okay, let's take a 5-minute break. But before that, any questions?
I want to ask lang po,
Go ahead.
regarding sa human rights. If there is a reparation of human rights, is it justifiable enough for those victims to achieve total justice po?
Sorry?
Am I audible po?
Yes, yes. Please repeat lang.
I will repeat the question po about human rights. If there is a reparation of human rights, is it justifiable enough for those victims to achieve total justice po?
To achieve total justice?
Yes po.
So, what you're asking is like, kung nagka-reparations na, yun na yun, total justice na yun.
Yes po.
Okay.
Tapos, is it justifiable po ba for them?
I think that one of the ways that you can view it is, yeah, when you do some reparations, that's okay na. Problem is, there's no one form of reparations that would be sufficient to fully repair or to compensate them for human rights violations, which is why in the Philippines, what we look at is holistic reparation. In the, what do you call this? There's, in international law, we recognize many different ways of doing reparations. And one of them is monetary compensation. But another one is symbolic reparation. So there are many different ways to do reparations, and they're not mutually exclusive. For example, in the case of Malaya Lolas, and this is why one of our sections is named Malaya Lolas, is because they were human rights violations victims, right? They were comfort women. And so they asked for reparations. The Japanese government did not offered money, definitely offered money, but they did not offer an apology. They didn't say that they were at fault. They didn't recognize the damage done by the comfort woman system. And so it was rejected. So later, ang hiningi ng Malaya Lolas, what they asked the government for is, can we please prosecute them? Let's go to an international court or international tribunal and prosecute the people who are responsible. And the government said, no, we don't want to do that because, first of all, it's not part of our foreign policy strategy at the moment. And secondly, with regard to reparation, you already received your reparation when you were given and offered the money. And it's not our fault that you refused the money. So when it got to the International Law Tribunal, the International Tribunal, I think it was the UN as well, what they said was there is no single way to make reparations for the damages caused by human rights violations. So total justice is a very difficult term because justice, like the ideal form of justice would be to go back in time and make it so that it never happened. But we need to do all we can to approximate that. And I think a good standard would be, what do the human rights victims feel is sufficient? Because if you are tortured, probably not enough. There's not enough money in the whole world that'll make you like feel that what was taken from you was back. So yun. I hope I answered your question. It's very debatable, right? Because you can use it as a justification, but I think realistically, it depends on what kind of reparation and how holistic that reparation was. I able to answer?
Thank you po.
Okay, any other questions? Okay, let's continue. Let's talk about domestic law naman. Here, I'm going to be talking about like the relationship between international law and domestic law. So there are two views that we have. One is the monist view, where we say that the relationship between international law and domestic law is that there is no difference. They're one and the same system. So therefore, international law would always be superior to domestic law. That's under the monist view. The Philippines does not use the monist view, but many treaties, including human rights treaties, use the monist view, which is why in the Vienna Convention of the Law on Treaties, if you sign a treaty and later you said, oh, the way that I signed the treaty wasn't compatible with my domestic or national law, the Vienna Convention says, that doesn't matter. You signed it already. So it's binding from an international law point of view, even if it's not binding from a domestic point of view. So many treaties use the monist point of view. But the Philippines uses the dualist view, which is the view that they are separate and distinct from one another. So, in order for international law to be part of domestic law, needs to internalize international law, to transform it in order for it or domesticate it in order for it to be applied to the Philippines. Otherwise, domestic law will trump international law. So it really so if you're gonna ask me like which is like superior, is it international law or is it domestic law? My answer is it depends on where it is. If you're going to litigate this issue in a Philippine court, they will say that it's domestic law. If you're going to litigate the issue in an international tribunal, they would say it's international law. So, how do we do domestication? Domestication is the process by which international law would be made part of Philippine law. So, when it comes to treaties are domesticated through a process of transformation. So there are two ways to do this. One is for Congress to actually make a law that recognizes the treaty or make a law that uses the same principles in terms of the treaty, such that even if the country pulls out of the treaty, as long as you have that law, it is still those international law principles are still part of domestic law. So one example for this is the Rome Statute. So as you might know, the Rome Statute is the treaty that would have made us part of the International Criminal Court, and it defines war crimes and crimes against humanity. And we pulled out of the IC during the time of Duterte. And so some people said that that's wrong. We shouldn't have done that. The Supreme Court said that, well, just because we're not part of the IC anymore doesn't mean we don't have measures that will protect against war crimes and crimes against humanity because we already created a specific law for that. So even if you're not part of the Rome Statute anymore, because in the past Congress has transformed international law into domestic law, it still remains domestic law even if you pull out of the treaty. The second way to do it, the less permanent way to do it, is to just consent to the treaty. So Congress, specifically Senate, has the power to say, okay, yeah, sign the treaty. We accept that treaty. Right? So when a treaty is signed and it is ratified by Congress, it turns into basically just like any other law. It is transformed into our legal system. But for customs, actually, we don't need to do anything because they're already deemed incorporated. Because in Article 2 of the Constitution, it says that we incorporate the generally applicable principles of international law. And one thing that you might notice is that generally applicable principles of international law, they're not one of the sources that I mentioned earlier. Hindi siya general principles kasi dapat generally applicable. So actually, generally applicable principles of international law refers to customs and general principles. So Customary law, even if you don't do anything, it's deemed incorporated already. It's deemed domesticated. So there's a 7-step process, and I'm borrowing this from Professor Raj Palacios. So there's a 7-step process before we apply international law to a Philippine case. First one is check if it's binding. Is it binding or is it a soft law? A soft law is just like the UDHR. It's just like a declaration of principles or a set of recommendations. So the World Health Organization, for example, gives a bunch of recommendations that is not binding. It's just soft law. It just says we're gonna pressure you into doing this, even though it's not a treaty, because it's like the right thing to do. The World Health Organization did that a lot with the pandemic. The International Labor Organization also does that with matters relating to labor rights. That's the first step. Check if it's binding or if it's soft law in general. Second, check what is the source. Is it treaty? Is it custom? Is it a general principle of law? And the reason why that is the case is the reason why this is an important step is it determines how do you domesticate it? How do you know if it's binding? So is it binding on the Philippines? So if it's a treaty, are we a party to that treaty? Right? Or if it's a custom, is it something that we've incorporated? And next, assuming that it is a treaty and assuming that we are a part of it, was it domesticated? Was it incorporated or transformed into domestic law? Next, this is very important. We cross the barrier from international law into domestic law because now that it's part of domestic law, what part of the hierarchy is it in Philippine legal rules? Because we have 4 tiers in the hierarchy. The highest tier is the Constitution. We cannot accept a treaty that would violate the Constitution. So one of the things that I ask people when they ask me about criminal law is, and one of the things that they also ask me is, if you commit a crime in, let's say, the U.S. Embassy, is that something that you can prosecute in Philippine courts? And many people would answer, no, you can't. Because if you're in the US Embassy, that's US soil. So you might have this misconception as well, but that's wrong. Because we have this idea of embassies because of the Vienna Convention on Diplomatic Relations. So imagine if you ratify the treaty that said, okay, if we establish an embassy, we lose a part of our territory. That would be contrary to the Constitution. That treaty, kung ganun nga talaga sinasabi niya, it wouldn't be valid. But since it is valid, we have to assume that this is not US soil. It's still Philippine soil, although there are some added limitations on this particular property. So yun, Constitution. You cannot have a treaty that is at the same tier as the Constitution. If it conflicts with the Constitution, it's out of here. It's void. It's unconstitutional. Next is a statute. So a statute is just like any other law. Let's say like the local government code or the Cybercrime Prevention Act or the revised penal code, etc., etc. I'll talk about why that matters later. The third one is executive, procedural, and local ordinances. This is the lowest tier because the executive branch cannot have orders, cannot do anything that conflicts with statutory law, with laws that are made by Congress. It can only implement nga eh. So it can't create new law. Same with local ordinances. Your local government unit does not have the authority to create laws or ordinances that contradict the national law or the Constitution, which is why they're the lowest tier. So next, what is the effect on existing Philippine rules? I'm going to talk about what if they're in the statute tier. There are three things that the court might do. If there is a conflict between a domestic law and an international law that we've domesticated, we can either fill in the gap, we can reinterpret. Reinterpret means let's find a way to make sure that both the national law and the international law are applicable at the same time, or there is a conflict between those two laws. And if there is a conflict between those two laws, meaning national law and the domesticated international law, we use the principles of statutory construction. Statutory construction is basically how the Supreme Court interprets laws, right? So three principles are very important here. One is lex superior. What is the superior rule? What is the superior law? So if it conflicts with the Constitution, since the Constitution is a superior law, the Constitution prevails. The next one is lex specialis, which is the special rule. So you're gonna look at, okay, this law is for the general rule. Generally speaking, this happens, but the international law is for this specific instance, then we should treat it like that. There's a general rule, but for this particular instance, international law applies, or vice versa. Sorry, vice versa. And lastly, lex posterior, which is about time. If there's no way to harmonize them, what you would say is the later law supplants the earlier law. Lex posterior. This means that essentially international law, once domesticated, is just like any other Philippine law. And lastly, apply it to the Philippine case. And this would mean one of four things: prohibit an action, compel an action to be done, allow an action to be done, or to declare a legal status. Okay? So we move on to the last part, which is about universalism. Universalism and human dignity is very important here because it's a debate with respect to human rights. Because some people say that it should be universal, some people would say that it's supposed to be like specific to a particular culture. Universalism posits that every human being, right, has inherent dignity. And that's where we base human rights. So, regardless of cultural, religious, or social background, you have those human rights. This perspective argues that all individuals possess certain rights simply by virtue of being human. And if you remember from the first lecture, that's the way that I introduced human rights, from a universalist approach. Because if you take a look at it from the viewpoint of international human rights law, they take a universalist approach. Some features of universalism involve international consensus. The universalist viewpoint is supported by the widespread acceptance of human rights treaties, such as the UDHR, ICPR, and ICSCR. The adoption of these documents by the majority of countries indicates a broad international consensus on the existence and importance of human rights. The next one is shared values across cultures, because universalists argue that many human rights principles, such as the right to life, freedom from torture, and equality before the law, are shared values that apply across different cultures and societies. So human rights are not solely a product of Western culture, but rather they reflect a common aspiration for human dignity and well-being. And lastly, one feature of universalism is protection of vulnerable groups because it emphasizes the importance of protecting the rights of vulnerable and marginalized groups such as women, children, and minorities. So by recognizing the universality of human rights, it seeks to ensure that all individuals are treated with equal respect and dignity, regardless of their cultural background. On the other hand, you have particularism or cultural relativism. So, with respect to diversity, this is the first point I want to make. Cultural relativism argues that human rights are culturally specific and that different societies should be allowed to determine their own values and norms based on their unique cultural contexts. So, this perspective values cultural diversity and respects the variety of ways in which societies organize themselves and understand the world. One critique that relativism has against universalism is the idea of Western imposition. This is the next point I want to make. Critics of universalism argue that the concept of human rights is a product of Western culture, and that imposing these values on non-Western societies is a form of cultural imperialism. They contend that universal human rights standards may not always be appropriate or relevant for different cultural contexts. And lastly, respect for cultural autonomy is a huge part of relativism as well, which emphasizes the importance of respecting the autonomy and self-determination of different cultures. By acknowledging the legitimacy of diverse cultural practices and beliefs, it seeks to promote a more inclusive and pluralistic understanding of human rights. So when they are pit against each other, we have to think about balancing rights and cultural diversity. The debate between universalism and relativism raises important questions about how to balance the protection of human rights with respect for diversity. So some people say that there is no difference because the best way, as I mentioned last time, the best way to respect cultural diversity is to make human rights apply universally so that everyone can enjoy their culture, right? But while some argue that certain rights are non negotiable and must be upheld regardless of context, others emphasize the need for flexibility and accommodation of different cultural practices. So, at some point, you can't skirt around it. There will be a tension between these two. So, the question is, how do you actually balance it? The next point I want to make is human rights dialogue, because the tension between these two schools of thought can also foster constructive dialogue between different cultures and societies. And that would promote a better understanding of shared values and common aspirations. So you engage in open and respectful discussions, it's possible to find a common ground. And when you find common ground, you develop mutually acceptable approaches to human rights protection. So what I would say is even if there's a conflict in the real world, all the more important it is to actually engage with international human rights organizations and institutions. Because, and this is the last point I want to make, we have a constantly evolving understanding of human rights. The debate between these two schools of thought highlights the dynamic and evolving nature of human rights as a concept. Because by continually reflecting on and reevaluating the meaning and scope of human rights, it's possible to develop more inclusive and context sensitive approaches to protection and promotion. As this leads me to the next part. I'm going to talk about emotion, which is this house prefers a world where international human rights law is formed on a regional basis rather than a universal basis. So on the left, what you would say is regional. On the right, you would see universal. So I made three quick arguments for either side. Let's talk about them a little bit. So for regional, what you can argue is that it fosters cultural understanding. So the premise is obviously that it's essential. Cultural diversity is essential to human dignity and the development of societies. However you wanna argue this is up to you, but this is basically the premise that you want to prove. The next step you want to say is, and again, however you prove this is up to you, but you have to prove this, that forming international human rights law on a regional basis allows for better consideration. Oh my god, hiccup. Forming international human rights law on a regional basis allows for better consideration of cultural differences and regional contexts, and that this approach encourages dialogue and cooperation among countries with shared cultural values, and as a result, we can tailor regional human rights law to respect and protect diverse cultural practices. So, it enhances cultural sensitivity and understanding and promotes a greater respect for human dignity. So, on a cultural level, regional formation of human rights allows for incorporation of diverse cultural beliefs and practices, and this also fosters mutual respect among different societies. But on a political level, you can also say that human rights laws may be more easily accepted by member countries because they're more likely to reflect shared values and priorities. You can also say that from a legal point of view, regional human rights laws can provide a more nuanced framework for addressing context-specific human rights issues because you take into account unique cultural and historical backgrounds. And lastly, on an institutional level, regional human rights organizations are better equipped to understand and address these specific human rights challenges, right? So you can also talk about like the different stakeholders like communities, governments, human rights advocates, stuff like that. So next, for regional, you can also argue ownership and enforcement. Basically, you want to say that forming international human rights law on a regional basis empowers regional organizations to take responsibility for monitoring and enforcing human rights standards within their territories. So this context-specific enforcement mechanisms will be tailored to their unique circumstances, and as a result, regional actors are more likely to be invested in the implementation and enforcement of human rights laws. So the counterfactual that you want to attack here is the Western imposition narrative. Since it's a regional thing, you no longer have this imposition narrative. So, in conclusion, forming an international human rights law on a regional basis facilitates regional ownership and enforcement. The case study I have here is Africa. Because as I mentioned earlier, Africa has a lot of regional human rights instruments, not just the Refugee Convention, which is the OAU Convention, right? That's the African Refugee Convention that was adopted in 1969 by the Organization African Unity, or the OAU. So the OAU Convention is a regional human rights instrument, but they also have the African Commission on Human and People's Rights, the African Court on Human and People's Rights, the African Committee on Experts on the Rights and Welfare of the Child, stuff like that. And also, some scholars have actually highlighted the role of these institutions in facilitating regional ownership and commitment to human rights norms and standards, because they're actually in there with in the weeds with everyone else. Lastly, I want to talk about cooperation and diplomacy in relation to regional human rights bodies. You can argue that regional cooperation and diplomacy are vital for addressing shared challenges. So, forming international human rights law on a regional basis encourages countries to collaborate on human rights issues and allows for the development of shared strategies. And as a result, countries within a region are more likely to engage in diplomatic efforts. So, with respect to governments, the effect here is increased diplomatic relations and diplomatic efforts to address human rights disputes, and the confidence that you build there also trickles down to other diplomatic issues. You also have, for the regional organizations, the effect here is they have a stronger capacity to address common human rights concerns and foster regional cooperation. But for individuals, the effect would be enhanced peace and stability within their regions, and that would contribute to improved human rights protection. Okay, on the other side of the coin, we have universalism. So one of the things that you can argue is that you risk undermining universal human rights standards. You create fragmentation if you have relativism. And this fragmentation could undermine the universality of human rights norms and would weaken the global human rights framework. And as a result, people in different regions may be subjected to varying levels of human rights protections depending on their particular human rights system. So it's no longer let's assure that everyone will have particular rights and like similar standards of dignity. Because if you're in a country or a state or a region that does not respect a particular right, you're very unlucky. And especially if one of the rights that they don't respect is the right to travel. If you are deprived of the right to travel, you can't even opt out. So if you're going to go back to this idea of Ubuntu, which came up in the grand finals of Worlds this year when Ateneo won, it's very difficult to opt out. And Ubuntu is the idea that you are made by and your obligation is primarily to your community. And opening opposition, that was Ateneo, said that it's very difficult for people to opt out, and you can't just assume that people can opt out. And their structural reasons were basically like, oh, because there's pressure from your community, stuff like that. But another layer to that would be, legally speaking, in that community, there might be legal barriers for you to exit. Because if you're in a society that prioritize Ubuntu, they probably do not have mechanisms that enable you to exercise your right to travel. So it's not just that you're pressured not to opt out. You physically cannot opt out because you do not have that right to do. So forming international human rights law on this basis risks undermining universal human rights standards, potentially leading to unequal protection for individuals across regions. Yan. Next, you can also argue that it diminishes the global accountability for human rights. The premise that you want to argue here is that human rights is a global and shared responsibility. So the core of this argument is that if you form regional human rights institutions, it weakens that shared accountability. It weakens global accountability mechanisms and oversight, because countries will now focus on regional standards and enforcement. So if the UN knocks on your door and asks you to do something because that's part of their monitoring and enforcement mechanisms, now you have an excuse to ignore them and say, oh, the African Commission's got this or the African Court has got this, even though there is a very weak reputation for the African Court and the African Commission. They have a very weak reputation with respect to implementation. right? So it weakens global accountability mechanisms. And because it's regional, it's more prone to bias, it's more prone to like manipulation and politics because they are so close to the stakeholders, right? And they're also probably close to the erring state parties. So forming international human rights law on a regional basis might diminish that. And lastly, it limits international cooperation and solidarity. I think that you can argue that international cooperation and solidarity are essential for addressing shared human rights challenges. So, forming international human rights law on a regional basis may lead to more insular focus on regional issues, and it hinders international cooperation and solidarity. And this is especially important for refugees because refugees are an issue that cuts across regions. So they might be in the Eastern European region, tapos pupunta sila sa Western European region, right? Or from Africa pupunta sa Europe. So if you're going to hinder international cooperation and solidarity, you can't just make regions everywhere. You can't have a region that is Turkey and Africa and Turkey and Europe and then Turkey with all of them. You can't have all of these because it's like multiplying exponentially the amount of paperwork that everyone needs to do and the amount of bureaucracy that human rights violations victims need to undergo in order to get redress. And so you can also argue that it's just that much more effective to have a single system. But also, this could reduce the willingness of countries to collaborate in global human rights initiatives, especially for, again, refugees. Because refugees, it's one of the principles in refugee law for states to share responsibility. It's the doctrine of shared responsibility. So, between regions, if they don't communicate with each other, that feeling of shared responsibility is also similarly diminished. And as a result, global efforts to address human rights abuses and promote peace may be weakened. So, in summary, there are so many debates that are about the philosophy of human rights law when it comes to universalism, when it comes to like even just the theories behind it. You can draw arguments from these theories. You can also draw arguments or at least framing from the way that the application of international law is constrained on a domestic level and the creation of domestic law is constrained the creation of international law is also constrained on an international law basis by the Vienna Convention on the Law of Treaties and the elements of a customary law. Yeah. So those are things that I want to impart to you tonight. That's it for my presentation. Thank you so much for attending again and listening. Do you have any more questions before we leave? My throat is actually killing me. Okay, if there are none, thank you so much. I'll see you in the next one. I think next week I'll talk about Bill of Rights or something if you're interested in that. But if you're also interested in some other field, just let me know. I might make that the next part. But yeah, Pancho, go.
Hi, Coach. This is not about our topic for today.
Yeah,
This is
go.
about the tournament. Student and then meron po siyang partner. Gusto siyang i-partner na hindi po student na outspoken. Is that possible for the tournament?
I will ask and I'll get back to you on this. But I'm leaning towards sure. Our preference is that students team up with each other because our coaches are already thinking about that. Please direct that student to let the coach know ASAP. Because we also need to
Okay
process
po.
because half of them free reg, half of them hindi pala free. Gets ba? We'd rather save
Apo,
us
apo.
the headache of determining sino ba free, sino ba hindi. Because you might end up just thinking na, ano, sige, let's ask them for a reg fee even though they're a student. We have our preferences, so we can't really compel people not to team up with whoever they want. That's a violation of your
Apo.
right to associate naman. Okay,
Thank you po, thank you.
you're welcome, you're welcome. Let the coach know. Let the coach know kung may plano nga ganyan. Okay, so that's it, everyone. Thank you so much. I'll upload this siguro Wednesday. By the way, I won't be able to attend the session tomorrow night because I'll be out the entire day for my oath taking and role signing. So, ayun, I already made I already made arrangements for actually for Pancho's class specifically for merging to happen. So yun. Thank you everyone. See you I guess in the next time we have one of these sessions. Bye.
Thank you po.
Thank you. Thank you.